Citizens no longer know what to believe. Once they lose trust in their leaders, in mainstream media, in political institutions, in each other, citizens.
All right, let's dive right in. We've got a mountain of legal documents and articles here, all about criminal discovery. And you know what? Turns out it's a pretty tricky area of law, even for seasoned lawyers.
Yeah, it's not exactly known for being straightforward.
So consider this deep dive your crash course on criminal discovery. We're going to break down the players, the rules, and those potential pitfalls that trip people up, especially when it comes to this thing called the Brady rule.
Right, the Brady rule, that's a big one. It's all about making sure both sides, the prosecution and the defense, have a fair shot at justice. Like, imagine you're prepping for a big debate. You need to know what arguments the other side is going to throw at you.
Makes sense. You don't want to walk into court blindsided, just like you wouldn't want to be caught off guard in a debate.
Exactly. Now, this doesn't mean it's a free-for-all information dump. It's not like handing over your entire case file and say, here you go, see what you can find. It's much more nuanced than that.
So how does it actually work? Is there some kind of standard procedure, or does it vary?
Well, it can definitely vary. Different jurisdictions have their own rules about what gets shared and when. Plus, the type of case, the stage of the proceedings, like whether we're talking pre-trial, trial, or even post-conviction, that all plays a role. It's not one size fits all.
Okay, so things can change drastically depending on the context. We're starting to see how tricky this can get. Speaking of tricky, one of the articles mentioned a prosecutor in Dallas who actually starts thinking about Brady during interviews. Apparently, he uses these hypothetical situations to get his team thinking about their disclosure obligations right from the get-go.
I've heard of that. It's an interesting approach for sure. I mean, on the one hand, it highlights the ethical tightrope prosecutors walk.
Yeah.
You're building a case, but you also have this duty to disclose anything that could help the defense, even if it potentially weakens your own position.
Right. Talk about a conflict of interest. And it's not just some abstract legal concept either. The same article mentioned that even law students don't get a firm grasp of Brady in law school. That's a little unsettling, don't you think?
It is concerning when you think about it, especially considering the potential consequences of getting it wrong.
Oh, absolutely. One of the cases you sent over involved a prosecutor in DC who actually had to dismiss a whole case because a Brady violation popped up late in the game. Talk about high stakes.
Oof, yeah, that's the nightmare scenario right there.
Yeah.
And it underscores just how crucial this pre-trial discovery phase can be.
It's not just about avoiding those courtroom disasters either, right? This pre-trial phase, it really sets the stage for how the entire case is going to play out.
Think about it. Early on, prosecutors might only have to disclose basic things like their witness list, which seems pretty straightforward. But as the case develops, they might uncover information, like, say, exculpatory statements from those same witnesses that they're obligated to share. It adds a whole other layer of complexity and strategy to the mix.
So we're not just talking about a routine exchange of information here. It's a strategic dance with potentially huge implications.
Absolutely. And that's where the Brady rule really comes into play. We flagged it as a major point in these sources, and for good reason. Essentially, it says that the prosecution must disclose anything that could be helpful to the defense, even if it weakens their own case. It seems counterintuitive, right?
It does. Why on earth would they ever do that? It seems like shooting themselves in the foot.
That's the part that often trips people up. The Brady rule, which stems from the landmark Supreme Court case, Brady v. Maryland, lays out a very specific three-pronged test. The evidence in question has to be favorable to the defense, it has to be material to the case, and it has to have been suppressed by the prosecution, whether intentionally or not.
Okay, so 3 prongs. Favorable, material, suppressed. Let's break that down a bit. Favorable seems straightforward enough. It's got to help the defense in some way. But what about material? Does it just mean anything that could be remotely helpful, or is there a higher bar?
Material is where the real battles are fought in Brady cases. We're not just talking about any old piece of information here. It means there's a reasonable probability that if the evidence had been disclosed, the outcome of the trial could have been different. It's about potential impact.
Ah, so it's not enough for it to be mildly interesting. It has to have the potential to actually change the course of the case.
Exactly. But of course, what constitutes a reasonable probability is up for interpretation.
Right.
And that's where things get tricky. Courts have gone back and forth over the years trying to pin down just how much of a difference the evidence needs to make.
I bet there have been some fascinating cases around that.
Oh, absolutely. One of the cases you included really highlights this. a conviction was actually overturned because the prosecution hadn't handed over information about their police informants.
Yeah.
And it turned out that information was crucial to the defense's case.
Wow. So materiality isn't just a legal term, it has real world consequences. Real people's lives are affected by this.
Precisely. And that's something that can't be overstated. These rules, these procedures, they have a direct impact on people's lives, their freedom, their futures.
You know, one thing I found particularly interesting in all of this is how courts are increasingly using this idea of due diligence by the defense to excuse Brady violations. It's like saying, well, if the defense had just dug a little deeper, they could have found this information themselves, so it's not really a violation. What are your thoughts on that?
Yeah, it's a slippery slope, isn't it? It raises serious questions about the power dynamics at play. Because shouldn't the burden be on the prosecution to disclose what they're obligated to, rather than expecting the defense to go on a scavenger hunt?
It does seem counterintuitive to the idea of a fair trial, doesn't it?
It does. And honestly, I think that's what makes the Brady rules so fascinating. It's not just about following the letter of the law, and with the very spirit of justice itself. These cases, these stories, they force us to ask some hard questions about what a fair trial really means and ensure the system is truly serving its intended purpose.
You know, it's almost like we've stepped into a legal thriller here. We've got this high stakes game of discovery going on with the Brady rule looming large, but now the plot thickens as we move into post-conviction territory.
Right. You'd think once the verdict is in, that's it, case closed. But it's not always that simple, not according to these sources you've shared.
It's kind of hard to wrap your head around, right? Someone's convicted, maybe even behind bars, and then boom, new evidence pops up that could change everything. And it's evidence that should have been disclosed all along, but wasn't.
It's not so much about dramatic twists and turns, though those do happen.
Yeah.
It's more about upholding fairness, the integrity of the legal system, even after a conviction is handed down.
So we're talking about appeals, habeas corpus, those kinds of things.
Exactly. Appeals, habeas corpus petitions, even civil lawsuits that stem from potential misconduct during the trial itself.
Yeah.
Those are all avenues where this post-conviction discovery can come into play.
And each of those has its own set of rules, I imagine.
Oh, absolutely. Appeals courts, for example, they're usually pretty hesitant to even consider evidence that wasn't presented during the original trial. Unless there's a really compelling reason why it wasn't, they're not inclined to overturn a conviction based on something new.
That makes sense. So what about habeas corpus petitions? Those are a bit different, right?
Right. Habeas corpus is specifically about challenging unlawful imprisonment. So those petitions often involve really digging into the trial records, looking for constitutional violations, which could include, you guessed it, Brady violations.
So it all circles back. One of your articles highlighted a California law, Penal Code Section 1054.9. That caught my eye. It's a post-conviction discovery tool, but it seems to give defense attorneys access to a wider range of information than in other states, even stuff beyond what the prosecutor's office has. What's the deal with that?
Yeah, that's a unique one. It's definitely been a hot topic of debate. On the one hand, you have proponents who say it's absolutely essential for correcting wrongful convictions. They argue that you have to leave no stone unturned in the pursuit of justice, casting a wider net for information.
Makes sense, but I'm guessing there's another side to that coin.
Oh, for sure. Critics worry that it could frivolous claims.
Discipline for a Brady violation they found after the trial was over.
That's right. And it underscores a really important point. The duty to disclose, it doesn't just disappear once a verdict is in. The integrity of the justice system hinges on everyone upholding their ethical obligations, win or lose.
It's about more than just notching a win in court. It's about ensuring justice is actually served, even if it means admitting to mistakes that are made along the way.
Exactly. Accountability is key. Now, we've talked a lot about prosecutors, but what about the role of law enforcement in all of this? They're the ones on the ground, collecting evidence, talking to witnesses. Do they have any skin in the Brady game?
That's a great point. It can't just be on the prosecutors, right?
Right. While the prosecutor ultimately shoulders the burden of Brady compliance, police officers are considered part of the prosecution team for these purposes. So any exculpatory information they have is also subject to disclosure.
That makes sense, but I bet figuring out what falls under that umbrella can get murky.
Oh, you bet. It gets very nuanced. Does it include stuff in an officer's personnel file? What about information held by a different police department altogether? These are the kinds of questions that have sparked countless legal battles.
So how do you even begin to navigate that?
Well, it comes down to this. The prosecution can't just ignore potentially exculpatory evidence simply because it's not sitting right there in their case file. If they know about it or should know about it, it falls under Brady.
I can imagine that creates a really interesting dynamic between prosecutors and law enforcement. It can't be easy for a prosecutor to go to a detective and say, hey, we have to hand over this piece of evidence that could tank our case.
It definitely requires a certain level of trust and a shared understanding that ultimately it's about the pursuit of justice, not just racking up convictions.
A delicate dance, to say the least. Especially if they involve allegations of misconduct, they could uncover a treasure trove of discoverable material, right? But isn't that information usually confidential?
Exactly. That's where things get really tricky. Protecting the confidentiality of police personnel records is important, no doubt. But so is upholding a defendant's right to a fair trial. Those two things, they can sometimes be at odds with each other.
So how do you even begin to reconcile that?
It's about finding that balance, which isn't always easy. To navigate this, courts have developed procedures for handling these types of requests. Often, they'll use something called an in-camera review.
In-camera review. Sounds kind of secretive. What's that all about?
It's basically a private screening process for sensitive documents. So the judge, they'll review these potentially relevant records privately in their chambers to see if there's anything in there that needs to be disclosed to the defense. They act as a sort of gatekeeper, protecting both the confidentiality of the records and the defendant's right to a fair trial.
So it's a way to thread the needle, essentially, to balance those competing interests without compromising either one entirely.
Exactly. Now, we've talked about the prosecution, the defense, even law enforcement, but what about the victims in all of this? Do they have any say in what gets disclosed during discovery?
That's a great question. It seems like their perspective often gets lost in the shuffle.
You're right. And it often sits at the heart of the tension between victims' rights and the defendant's right to discovery. There's been a growing emphasis on victims' rights in recent years, and with good reason.
Absolutely.
So there are laws in place to protect their privacy, which could limit what information gets disclosed. Things like their contact information, medical records, anything deemed too sensitive.
It makes sense to protect that kind of information, but I can see how that could create some tricky situations, especially if that information is also relevant to the defense's case.
Exactly. It's a tightrope walk for the courts. They have to weigh those competing interests very carefully. There's no easy answer, no one-size-fits-all solution.
So what's the takeaway here? How do we reconcile these different perspectives and ensure that everyone's rights are being respected?
Ultimately, it comes down to this: finding a way to uphold the dignity and the rights of all parties involved, the defendant, the victim, society as a whole, while still ensuring that the pursuit of justice remains the top priority. It's about striking that delicate balance, even when it's difficult.
That's a great point. You know, as we've peeled back the layers of this whole discovery process, it's become clear that it's about far more than just rules and procedures. It's about upholding the integrity of the entire system and making sure it serves its intended purpose, justice.
Absolutely. It's about getting it right, not just getting a conviction.
We've explored the ins and outs of pretrial discovery, the complexities of the Brady rule, and now the often overlooked realm of post-conviction discovery. But in the midst of all these rules, these procedures, these legal battles, I keep coming back to this question. Is the system actually working the way it should be? Are we actually achieving justice? Or are we, as you said earlier, getting lost in the weeds? That's the question that keeps coming back to me too. It's like we've been on this journey uncovering all these intricacies of criminal discovery, the rules, the cases, the ethical dilemmas. But where do we end up? Are we actually achieving justice or just getting lost in the legal weeds?
It's the million-dollar question, isn't it? And it's interesting you phrase it that way because that actually ties into the final thought-provoking point that you highlighted from the source material. It challenges us to zoom out, to look beyond the chess game of discovery and think about the big picture, the spirit of justice. If that's truly the goal, shouldn't the system be geared toward transparency, not strategy?
So less about trying to outmaneuver the other side and more about putting all the cards on the table right from the start.
Exactly. What if, instead of this intricate dance of disclosure, both sides just laid it all out there? Imagine a system where evidence is shared openly, proactively, right from day one? Could that lead to quicker resolutions, fairer outcomes? Could it even foster a stronger sense of trust in the judicial process?
It's a compelling thought experiment for sure, but I have to admit, I'm a little hesitant to fully embrace it. I mean, how do you protect sensitive information in that kind of system? And how do you prevent one side from drowning the other in a mountain of data, potentially burying crucial evidence in a sea of irrelevant documents?
You're right, those are real concerns. It would require a monumental shift in how we think about criminal justice, both from the prosecution side and the defenses. No more gotcha moments, no more holding back the trump card. Instead, a genuine collaborative search for the truth.
It would be a complete overhaul, wouldn't it? Shifting the entire system away from this adversarial battle of wits towards something, I don't know, more truthful.
More transparent, perhaps. More focused on justice than on securing a win. It's definitely a conversation worth having. These sources you've shared, they've really opened our eyes to both the strengths and weaknesses of the current system, its complexities, its contradictions.
They really have. It's like we've peeked behind the curtain and seen the machinery at work.
Exactly. And now it's about deciding whether that machinery is still serving us well, or if it's time for a redesign.
A redesign of the system itself. That's a pretty profound thought. And honestly, after this deep dive, I think it's the perfect note to end on. We've explored the intricacies of criminal discovery from the pre-trial stage all the way through post-conviction, and we've wrestled with the big questions, the ethical dilemmas that sit at the heart of it all. But ultimately, the answers, those are for each of us to find. So, to our listeners, as you continue to explore these issues, as you encounter these real-life examples playing out in the news, in your communities, ask yourselves, is the current system the best we can do? Can we strive for a more just, a more transparent approach to discovery in criminal cases? These are not easy questions, but they're questions worth wrestling with. And that's what this deep dive is all about. It's about equipping you with the knowledge, the context to critically examine the justice system and envision a better way forward.
AI and the law, huh? Okay, so we're diving into some interesting stuff with your request today. Holding corrupt officials accountable. You sent over some legal documents, police complaints, qualified immunity, and this idea of commercial liens. I gotta say, when I first saw that, my ears perked up. Feels like we're about to uncover some kind of secret path to justice.
It is fascinating how these documents connect these seemingly like totally different issues to reveal a potential strategy, one that goes way beyond the typical lawsuits. We see these complaints about police misconduct, discussions of qualified immunity, and then boom, these little hints about commercial liens as a tool for justice.
Yeah, it's like finding a secret weapon hidden in plain sight, hidden inside these legal documents. So break this down for me. What is a commercial lien in this context? And how does it even apply to holding like a police officer accountable?
So a commercial lien, as it's presented in these documents, it's a way to declare a debt. But here's where it gets really interesting. It's not just about money. They're talking about debts of obligation, debts of honor, even debts related to violations of constitutional rights. So imagine a police officer. Let's say they violate someone's Fourth Amendment right, the right against unreasonable searches and seizures. The document suggests that this could actually be framed as a debt because the officer is bound by their oath to uphold the Constitution.
So instead of a mechanic's lien for like an unpaid car repair bill,
Yeah.
we're talking about holding a police officer accountable for violating someone's rights and potentially like bypassing qualified immunity. How would that even work?
That's the big question, right? These documents argue that commercial liens, they operate under the principles of commercial law. This is a system where truth and clear documentation are the most important things. So it's about using that framework to hold individuals accountable for their actions, even if those individuals are public officials.
Okay, but I'm still trying to wrap my head around all of this. How does a lien, which I usually think about with property, how does that translate to someone's rights being violated? What would this meticulous documentation to support a lien look like in this situation?
Okay, so imagine this. You have a police complaint and it details the alleged violation. You have evidence, maybe body camera footage, witness statements, medical records, and you have a deep understanding of the specific constitutional rights that were potentially broken. This documentation becomes the basis of your lien. It's about building a case, not just on the violation itself, but on the violation of the officer's sworn duty to uphold the Constitution, a debt of obligations, so to speak.
So it's not just about saying this officer did something wrong. It's about this officer violated their oath and therefore owes a debt to the person whose rights were violated. It's a really interesting argument.
And these documents suggest that by filing a commercial lien based on this argument, you're basically shifting the responsibility of proof. So instead of you having to prove your case in a lengthy and expensive lawsuit, the burden falls on the accused party to disprove the claims that you made in the lien. It forces them to address the alleged violation of their oath and the debt that they've incurred because of it.
That's a bold claim. But what about these cases that we hear about, where people get into legal trouble for filing what are called bogus liens? Is there a real risk there?
Absolutely.
Yeah.
These documents don't shy away from that risk at all, especially the Step 07 commercial lieners document. It makes it very, very clear. This is not about harassing people you just don't like or trying to get out of paying taxes. There are right ways and wrong ways to use this strategy. They even caution against organizations that offer these really simple solutions because this requires a deep understanding of the law and a willingness to work within a very complex system.
So this is not a get out of jail free card or some kind of magical legal loophole. This sounds like it requires careful consideration.
Just thorough research.
And a really strong understanding of the law and also the specific details of the alleged violation.
Precisely. And even then, success is not guaranteed. These documents are presenting a potential path, a different lens for how to view accountability and the power of commercial law. But they are definitely urging caution and careful consideration.
It's like they're saying, here's this potential tool, but you need to know how to use it. It's a good reminder that the pursuit of justice often requires thinking outside the box and being willing to conventional approaches, but it demands caution and a deep understanding of the system.
Has qualified immunity, which, as you know, can be a major obstacle in holding officials accountable.
Right. Like in that case we saw, Magdalena Moll's complaint in the Northern District of Illinois. She alleges some really serious abuse of power by this police officer. But if qualified immunity protects that officer, what recourse does she even have?
That is exactly the kind of scenario where these documents suggest that commercial liens might be an alternative route. They argue that by framing the issue as a violation of the officer's oath and the resulting debt, you're shifting the legal playing field away from the traditional lawsuit framework where qualified immunity often protects them.
So it's like saying, we're not playing your game anymore. We're taking this to a different court where the rules might be more favorable to holding you accountable.
In a way, yes. It's about leveraging a different set of legal principles, the ones rooted in commercial law, to potentially work around the protections of qualified immunity.
That is incredibly intriguing. These documents also mention the Charles Ronald Gray case in Georgia. How does that case factor into this idea of using commercial liens to challenge power and seek justice?
The Gray case. While it is a complex case with its own unique circumstances, it serves as an example of how some individuals are attempting to use commercial liens to target what they see as systemic corruption in the government.
So it's a real world example, albeit a complex one, of someone attempting to actually put these theories into practice. But as these documents emphasize, this is not something to be taken lightly. There are potential risks and consequences to consider every step of the way.
Absolutely. These documents are a call for informed action. They're urging anyone considering these strategies to really do their homework, understand the potential risks, and proceed carefully. Knowledge is power, especially when you're working within the legal system.
This is already so eye-opening. We went from police complaints to qualified immunity, and now to this really fascinating idea of commercial liens as a potential tool for holding officials accountable. I feel like we've only scratched the surface here.
One thing about these documents I find super interesting.
Like the kind of bond a bail bondsman would post.
Bonds. And these documents suggest that these bonds, which are often required for public officials, by the way, they could be a really important part of this whole accountability thing. It's about making sure that if an official doesn't actually perform their duties legally, there's a way to compensate the people who are harmed.
Okay, so less about getting out of jail and more about having some kind of insurance policy in place for when officials abuse their power.
Exactly. Think of it like this. An officer takes an oath to uphold the Constitution. These documents are saying that violating that oath, it's not just some kind of like moral failing, but it could actually be a breach of their bond agreement.
Okay, hold on. So if a police officer violates someone's rights, are you saying there's a chance the victim could actually use that bond to cover damages?
That's the idea they're putting forward. But it gets even more interesting. These documents link the bond to the official's oath of office in this really fascinating way. They argue that if the oath itself is messed up in some way, like maybe it wasn't filed correctly or it's missing some super important element, it could actually make the entire bond invalid.
Wait, you're telling me like a misplaced oath? Some kind of bureaucratic error? That could be all it takes to unlock some accountability for really serious misconduct. That seems kind of crazy.
It might sound kind of out there, but remember all that meticulous documentation we talked about? These documents suggest that even small procedural mistakes, if they're documented really clearly, could potentially undermine an official's defense, especially when they're hit with a commercial expense.
It's like they're saying you want to play by the rules, fine, but you better make sure you're following all of them, even the ones that seem like technicalities. This is starting to feel like some high-stakes chess game.
Exactly. And that's why the documents emphasize so much that this isn't about just filing whatever claim you feel like or going on a witch hunt. This is about taking informed action, right? Thinking strategically and really understanding the extremely complex web of laws and procedures that are involved here.
It's about giving people the power to hold these powerful people accountable, but doing it in a way that is responsible, well-informed, and based on a deep respect for the law, even if you're trying to find its limits.
Exactly. We've been talking about these commercial lanes as a potential secret weapon, but it's super important to remember that even with the best intentions, there's always a risk of someone using these tools the wrong way or having outcomes you didn't expect. That's why I found the Step 07 commercial lanes document so interesting. It actually says that for most people, it's probably better to just read this stuff like an adventure novel than to actually try to use these strategies themselves.
Oh yeah, that disclaimer definitely caught my eye too. It kind of speaks to the complexity of this whole thing.
Yeah.
And the fact that there could be some serious consequences if you get it wrong.
Yeah.
We're not just talking about some theory here. This is about people's lives,
Mm.
their freedom, potentially their entire livelihood on the line. It's really serious stuff.
Absolutely. And that brings us back to the listener, to anyone who might be going through something like this right now, dealing with the fallout of police misconduct, dealing with qualified immunity, feeling like the system is totally against them. What's the takeaway for them?
That's a lot to think about. On the one hand, we've got this potentially really powerful tool for trying to find justice, for holding officials accountable when the traditional ways don't work. But on the other hand, there's this really clear warning. Be so careful, understand the risk, and be prepared for this to be a really difficult process.
Yeah, you put that perfectly.
So what's the first thing someone should do if they're listening to this and they're thinking, okay, this is really interesting, I want to learn more? Where do they even begin?
Yeah, it does feel like you need a law degree just to wrap your head around the basics, let alone actually try to use any of this stuff. These documents open up a whole new way of thinking about the law and how it can be used to hold the powerful accountable, but they don't make it easy.
Yeah, and they're very upfront about the risks, which honestly I appreciate. But being realistic for a second, let's say someone is listening to us and they're not a lawyer. What can they actually do? Like concrete steps to learn more and maybe see if any of this is relevant to their own situation.
Well, the documents emphasize a few key things. First, research. And I don't mean just doing a quick Google search for commercial liens. This means really digging into the legal code, specifically in your jurisdiction. The rules about filing a lien, the kinds of debts it applies to, the procedures for challenging one. All of this can be totally different from state to state, even county to county sometimes.
So basically, don't just take our word for it. Go look it up yourself. Understand the law in your area.
Exactly. And that research shouldn't stop at just commercial liens. Remember how we talked about how these documents connect all these different things? Police complaints, qualified immunity, surety bonds. Understanding each of these areas is super important if you want to build a really solid case for taking action.
It's about seeing the big picture. How do all of these different pieces of the legal system work together?
Right. And that brings us to the second step. Connect with other people who are doing this work. There are organizations out there, networks, just individuals who have experience with this stuff. Commercial lease, qualified immunity, they can give you guidance and support.
But like we've been talking about, not all advice is good advice. These documents warn about groups that offer these oversimplified solutions, or they take advantage of people who are already frustrated with the system. So how do you know who to trust? How do you find good information and support? in a field that seems like it could be so easily abused.
That's where you have to be really careful. Look for organizations that have a real track record. They understand the law and they're committed to doing things the right way. Read what they have to say. Ask them the tough questions. And don't be afraid to walk away if something doesn't feel right.
Trust your gut on that one. If a group is promising you the world, guaranteeing certain outcomes, or pressuring you into doing something before you're ready, run the other way.
Exactly. Remember, this is about giving you power, not taking advantage of you.
And even with all the research in the world and the best support you can find, it's important to be realistic. Getting justice is usually a long and difficult process.
These documents are very clear about that. They don't try to make it seem easier than it is.
But there is a sense of hopefulness in them too. Like even with all the warnings and the disclaimers, there's this underlying message about not giving up, about the power of regular people to stand up and make a difference.
It's like they're saying, we're not going to pretend this is easy, but we believe in people's ability to do the right thing, to challenge what's wrong, to demand better from those in power.
And that is what I find so interesting about all of this. We started with these documents, talking about police complaints and qualified immunity, and then this thing I'd never even heard of, commercial liens. But it's so much bigger than that.
It really is. It's like we've uncovered this map. That might show us a way to challenge power, to bring about some real accountability, and to make the world a more just place. And even though the path might be long and difficult, it's a journey worth taking.
It definitely is. And for anyone listening who feels the same way, anyone who wants to learn more, explore these ideas, connect with others who are doing this work. Know that you're not alone. And that first step is right there waiting for you.
Good afternoon, everybody. I am back, and I'm your host, Supreme Litigant.
Okay,
And I'd like to thank everybody who has subscribed to my channel. I really appreciate it. If you haven't already, please, please, please do me a favor. Go ahead and pound that like button and that subscribe button. I'll give you a second to do that. Okay, yesterday, either I think it was yesterday or this morning. I can't really remember, but I did a poll on YouTube, and I was asking if y'all could understand the distinction between a reasonable officer and an unreasonable officer. And so it seems like, some of y'all are having problems with understanding it. So that's why I made this video. I just typed this up. It probably took me maybe about 45 minutes to an hour or something like that. So I'm going to explain to you using a scenario that I made up on what a reasonable officer is and an unreasonable officer is. Okay, the first thing y'all need to understand is this reasonable officer thing, this is a fiction. Okay, the courts made this up. Okay, so that is why you see this here in blue. I'm gonna read it to you. Okay, a reasonable officer is a fictional officer created by the courts as a tool to determine if the real officer acted reasonable or unreasonable according to the facts and clearly established law. So we're going to say this right here in this fact section. We're going to say that this is a real scenario, that this actually happened for real. We're going to assume that this actually happened for real. So Officer Trey Gavin, the real officer, stops you for speeding and issues you a traffic citation. After Officer Trey Gavin gives you the citation, you smack your lips and say, "Fuck the police." Okay. Can the real officer, Trey Gavin, arrest you for saying, "Fuck the police"? Can he do that? Let's go down and see. Here's the clearly established law. Here's the relevant case law. Saying and showing and putting him on notice that he cannot arrest you for saying, "Fuck the police." Saying "fuck the police," although vulgar, was a First Amendment protected activity. And here's the cases, right here in support of this contention. Y'all can go and read. Let me rephrase that. Y'all should go and read these cases because this is common law. This is where your rights are. That's why you need to go and read case law. That is where the common law is. Go read the cases if you want to know what your rights are and how to properly allege a valid cause of action against these tortfeasors, these idiots. That's what y'all need to go and do. Go read the cases. So let's go back up and I'm going to answer your question. The answer is no, he can't arrest you for that. So since the officer does not arrest you for saying fuck the police, he acts reasonable, aka lawful, according to the facts and clearly established law, meaning you cannot sue him. But if the officer does arrest you, he acted unreasonable, aka unlawful, according to the facts and clearly established law, meaning you can sue him. And if you allege those facts and only those facts in that complaint under your ultimate facts section of your complaint, you are going to win because he is not going to get granted any form of immunity because he violated clearly established law of which a reasonable officer would have known. Do y'all see what I'm saying? You see, the reasonable officer right here didn't arrest him. You see that? The fictional reasonable officer did not arrest him. But the real officer, the idiot, he arrested him. So he acted unlawful, aka unreasonable. You got to pay for that. So make sure that they pay for that. Anytime they do something to y'all, make sure that they pay for it. Unless they had a lawful purpose for doing something to you. Simple. That'll be the end of this video. Hopefully it helped. I think that was a pretty good example. If not, let me know. And I'll try it another way. I'm going to put another poll up probably later on tonight or tomorrow evening or something like that. And I'll ask this same question. The Supreme Litigant is out. Peace.
The major complaint about defense attorneys is that they do not communicate regularly with clients. Let's take a look at defense attorney misconduct. Complaints received by bar associations generally involve clients who believe that they're not getting what they paid for. One of the most cited reasons for false convictions, in addition to eyewitness testimony, is ineffective assistance of counsel. Other behaviors reported of lawyers in capital and other cases include the following: the use of heroin and cocaine during trial, letting the defendant wear the same clothes, admitting that they didn't know the law or the facts, not being able to name a death penalty case, and drinking heavily each day of the trial. Cases identified by the Innocence Project include many examples of criminal defense attorneys not bringing forward evidence. When prosecutors forget that their mission is to protect a due process, not merely win a case, misconduct can occur. The types of misconduct range from minor lapses of ethical rules to commissions of criminal acts. Most prosecutor misconduct involves unethical or illegal means to obtain a conviction. Experts discuss 4 types of prosecutorial misconduct: withholding exculpatory evidence, misusing pretrial publicity, using false evidence in court, and using preemptory challenges to exclude jurors. Rules forbid an attorney from knowingly allowing false evidence to be admitted. Misconduct also occurs when prosecutors intentionally use scientific evidence that they know to be false. Prosecutors might also bolster a witness's credentials or allow him or her to make unsupported claims on the witness stand. Judicial canons require judges to avoid even the appearance of bias or impropriety. There is a prohibition on attorneys and judges discussing a case outside the presence of the other attorney. This is called ex parte communication and is prohibited because it gives one side preference over the other. The expectation that judges maintain an unbiased position towards any issue that might come before him or her. Various forms of judicial misconduct include the following: failing to inform defendants of their rights, coercing guilty pleas, exceeding sentencing authority, and exceeding bail authority. Further, denying full and fair hearings or trials, abusing the criminal contempt power, ignoring probable cause requirements, denying defendants' rights, and penalizing defendants for exercising their rights. We must be careful not to paint with too broad of a brush. Only a few judges are involved in the most egregious examples of unethical behavior. Most judges are ethical and take great care to live up to the obligations of their role. The factors that seem to be correlated with wrongful convictions clearly indicate that legal professionals must take responsibility for reducing the possibility of such gross miscarriages of justice. It should be recognized that while sometimes prosecutors are implicated as pivotal in wrongful convictions, in other cases, prosecutors have been pivotal in helping free someone. When wrongful convictions were compared with cases where a factually innocent defendant was indicted, but the prosecution was dropped or didn't resolve the conviction, research has found that these factors influence the likelihood of wrongful conviction. State punitiveness, a weak case, error in forensic testimony, age and prior criminal history of the defendant, honest mistaken identity by an eyewitness, and poor representation by a defense attorney. Other factors include perjury by informants, police and prosecutorial misconduct, false confessions, junk science, ineffective assistance of counsel, and so on. Mistaken eyewitness testimony is the most frequently identified factor in wrongful convictions. False confessions are another important factor in wrongful convictions. A study of 250 exonerees found that 70% were minorities. Confirmatory bias is when someone ignores evidence that is contrary to what they believe. Confirmatory bias may lead to wrongful convictions because prosecutors ignore evidence that tends to refute their theory of the case. Individuals may be affected by confirmatory bias in that they can truly not see the exculpatory nature of evidence because they believe so strongly that a defendant is guilty. The reality is that the law is administered by humans, and human beings have failings and errors and misconduct that can result in innocent people being convicted, incarcerated, and sometimes executed. In response to questions about why prosecutors commit various forms of misconduct, one commentator explained, because they can. We can discuss several psychological processes that contribute to misconduct, including the presence of confirmatory bias, selective information processing, belief preservation, and avoidance of cognitive dissonance. Intentional prosecutorial misconduct can include reconstructing conduct as morally justified, obscuring personal agency, and blaming or dehumanizing defendants. The immunity of judges insulates them from the effects of their decisions, although their decisions are public and can create storms of controversy. State judicial commissions rarely sanction judges, and voters tend to be oblivious of the reputation of judges. A range of potential responses to prosecutorial misconduct have been offered or implemented. Many of these have weaknesses that prevent their effectiveness. To enforce rules of ethics, the American Bar Association, or the ABA, has a standing committee on ethical responsibility to offer formal and informal options or opinions when charges of impropriety have been made. Disciplinary committees investigate a practicing attorney only when a complaint is lodged against him or her. One of the most common complaints against attorneys is that they allow deadlines to pass or miss court dates. It seems that prosecutors may be even less likely to be the target of bar discipline committees than criminal defense attorneys. Misconduct in the courtroom is sometimes morally sanctioned by trial judges, but prosecutors are rarely directly mentioned in appellate holdings, even when case decisions are overturned. Some have argued that the evidence of prosecutorial misconduct supports rethinking prosecutorial immunity and perhaps employing criminal sanctions against prosecutors. There is some argument that prosecutors do not get sufficient training on Brady obligations that then meet some of the Brady violations that appear in wrongful convictions. Prosecutors' associations advocate enhanced training on Brady obligations to reduce violations. While the number of innocent project affiliates is growing and groups have been successful in identifying cases and prevailing in court, they can't be the only solution to the problem of false convictions. DNA has been the vehicle by which many innocent prisoners have obtained their release from prison. Because of the pro-prosecution bias that is said to exist in state or local police crime labs, there have been calls for private labs to test evidence. Procedures can also ensure that obtaining confession occurs in a manner designed to minimize the potential for false convictions. There is new attention to and interest in addressing the weaknesses of the justice system to reduce the number of wrongfully convicted people. The way to reduce misconduct includes 5 approaches. First, instituting an open file pretrial discovery. Second, abandoning the harmless error test. Third, identifying errant prosecutors by name. Fourth, stripping prosecutors of full immunity. And fifth, investigations of misconduct by prosecutors. Ethical misconduct by prosecutors is expensive and threatens the very legitimacy of our legal system. Just because there's an allegation in an appeal that prosecutors engaged in misconduct does not make it so. Individuals on the side of defending the wrongfully convicted may be subject to confirmation bias as well and have their own ethical blinders on. Far from being static, the implementation of law reflects political realities, in direct contrast to the ideal of judicial independence that is the cornerstone of our system of government. If the judiciary is not independent of political powers, this calls into question the very existence of the checks and balances upon which this country's government is constructed. The system of federal prosecutors and the federal law enforcement agencies, which include the Federal Bureau of Investigation, as well as many others, is also supposed to be removed from political influence. If the justice system, including prosecutors and judges, is a pawn or an agent of political power, due process is a sham, and the very essence of democracy is threatened. The importance of due process is that even criminals and enemies of the state are given due process rights that protect them from errors and deprivation of life, liberty, and property. The U.S. Supreme Court, as the ultimate authority of the law in this country, decides constitutionality, and these interpretations are far from neutral, despite the myth of objective decision-making. Our law derives from the Constitution. 2 basic philosophies regarding how to apply constitutional principles are at work in the legal arena. The first group might be so-called strict constitutionalists, because they argue that the Constitution should be implemented as written, and any changes are to take place in terms of rights, responsibilities, or liberties. The changes should take place through the political system or Congress. Activists have a looser reading of the Constitution and read into the rights that framers might have recognized or should have recognized because of evolving standards. They argue that the Constitution is meant to be a living document and that the language of the framers was intentionally written as an accommodating interpretation based on changing times and circumstances. The major complaint about defense attorneys is that they do not communicate regularly with clients. Let's take a look at defense attorney misconduct. Complaints received by bar associations.
Welcome to the deep dive. Today we're all about RICO.
RICO?
Yeah, the Racketeer Influenced and Corrupt Organizations Act.
RICO.
But we are ditching the stuffy law school vibes today.
Yeah.
We're gonna have like a real down-to-earth conversation about it.
Sound good.
You might think of like mobsters and backroom deals.
It certainly started there.
Right.
but it's become a lot more interesting since then.
Yeah, it's like Reiko traded in like the pinstripe suit for a power suit.
Exactly.
So you gave me a stack of materials to prep for this.
I did.
We have court cases, a Reiko guide, even a handbook for law enforcement.
Wow.
It's a lot.
Yeah.
So let's crack this case wide open, so to speak.
Let's do it.
Uncover what makes Reiko tick.
Absolutely.
Okay, so I have to admit, when I hear Reiko, my mind goes straight to like mobster movies.
Mhm.
Of course.
Goodfellas, Casino, that kind of thing.
Yeah.
Is that totally off base? Like, what's the real deal with this law?
Well, you're not wrong to think organized crime.
Okay.
Because ARICO, it was originally passed back in 1970
Mhm.
to target the mob.
Okay.
But, and this is where it gets interesting, it's actually become this very versatile tool that's used in a much wider range of cases today.
Like what?
So we're talking about things from financial fraud to abortion.
Wait, hold on. Abortion.
Yeah,
That's not something I would ever pictured ARCO being involved in.
right.
How does that even work?
It just goes to show how much this law has expanded.
Okay.
So we're talking about cases that allege extortion by anti-abortion groups.
Okay.
Think tactics like threats, intimidation.
Things like that can fall under RICO's definition of racketeering activity.
So it's not just about like, you know, the Godfather anymore.
No,
It's about any group that's engaged in a pattern of serious criminal activity.
that's exactly right.
But why is that pattern part so important?
The pattern idea.
Yeah.
That's really the cornerstone of RICO.
Okay.
It's not about punishing a one-off crime.
Right.
It's about going after that criminal enterprise.
Okay.
Their structure, their methods, their ongoing criminal activity.
So less about catching someone red-handed, more about proving they're part of a larger machine, essentially.
Exactly.
Okay.
And to build that RICO case,
Uh-huh.
you have to establish that there's either a person or an enterprise behind it all.
Okay, so now it's getting a little nuanced for me.
A little bit.
What's the difference between like a person and an enterprise when we're talking about RICO?
Well, a person in RICO, it can be an individual.
Yeah.
But it could also be a corporation,
Okay,
a legal entity.
got it.
It's broader than you might initially think,
Okay.
but an enterprise is where it gets even more interesting.
All right, I'm ready to be interested. Lay it on me.
An enterprise is a group of individuals
Okay.
who are working together for a common purpose.
Okay.
And that purpose involves racketeering.
Oh,
So this could be as, structured as a company using its employees and resources to commit fraud.
right.
Or it could be as loosely organized as a group that's fixing prices in a particular market.
So my like weekly poker night, probably not an enterprise.
Probably not.
But if we were like laundering money through the poker chips,
Well, then you might want to consult with an attorney.
yeah, exactly.
But the main thing here is that you can't have an RICO case without that two-pronged approach,
Okay,
identifying the person pulling the strings,
right.
and the enterprise, that's the vehicle for their criminal activity.
Okay, so we've got our persons, we've got our enterprises.
Oh, exactly.
Okay, so we've got our persons, we've got our enterprises.
All right.
But those sound like, the makings of like a corporate merger,
Right.
not necessarily a racketeering case.
Yeah.
So what actually tips the scales here?
Yeah, that's where our old friend pattern comes back into play.
Okay,
Remember, it's not about a single act of fraud
right.
or one instance of intimidation.
RICO wants to see that you're in it for the long game.
That's right.
So how do you actually prove that pattern of racketeering activity? What does that look like?
We have to connect the dots between those individual crimes,
Okay.
which legally are called predicate acts.
Predicate acts.
Yeah, and demonstrate a pattern of behavior,
Okay.
a deliberate and ongoing scheme.
So instead of just busting somebody for like one bank robbery,
Right.
they're trying to show this whole web of like heists and money laundering and maybe even ties to like corrupt officials and things like that.
You got it.
Okay.
And you bring up a good point there,
Yeah.
because that list of potential predicate acts under Archeo,
Yeah.
it's surprisingly long and varied.
Really?
Oh, yeah.
Okay.
Of course, you've got your classics.
Yeah.
Bribery, extortion, fraud.
Usual suspects, organized crime.
Exactly.
Yeah.
But it goes way beyond that.
Okay.
Things like illegal gambling,
Okay.
trafficking in counterfeit goods,
Mm-hmm.
even certain environmental crimes.
Really?
Oh, yeah, can fall under ICO.
Wow.
It's pretty broad.
That's a pretty wide spectrum
Yeah,
of criminal activities.
yeah, it is.
That's a lot of power
It is. It is
for prosecutors.
for prosecutors.
Yeah.
And what might surprise you is that ICO isn't just about throwing the book at criminals in criminal court.
Oh,
It has this whole other side to it
okay.
that really empowers everyday people
Really?
to fight back
Okay.
against this kind of activity.
Wait, are you saying there's a civil component to ICO?
A civil component.
Okay.
Like people can sue under this law.
Right.
That's exactly right.
Oh, then.
It's one of the most fascinating things about it.
Really?
Yeah, individuals
Oh.
who've been harmed by a RICO enterprise,
Okay.
financially or otherwise,
Okay.
they can actually file civil lawsuits
Okay.
to try to get some compensation.
So let's say, like, you could prove that you lost your savings
Right.
because of some fraudulent investment scheme
Yeah.
that was orchestrated by a ICO enterprise.
Right.
You could use RICO to go after them.
Potentially
Yeah.
in civil court.
In civil court.
That's amazing.
It is. It gives victims a way to not only stop this activity,
Oh,
but to recover damages
okay.
and potentially get some justice.
I can see why this is a law that's in the headlines pretty often these days.
Absolutely.
Do you have any like examples of civil ICO cases that illustrate how it works? Yeah. So you mentioned the mining company that used RICO to sue its union for violence and intimidation during a strike,
Right.
which is fascinating.
So even though it was a labor dispute,
Yeah,
they were saying that the union's tactics were actually racketeering.
exactly. They met that definition.
Interesting.
And there's tons of other examples out there.
Okay.
Small businesses driven under by unfair competition, whistleblowers facing retaliation,
Okay.
things like that.
So it's really about proving that pattern of harm.
It really is.
That comes from that racketeering activity.
It comes back to that pattern. Yeah,
Okay, let's say someone's listening to this right now
right.
and they're thinking, hey, I think I might have a RICO case on my hands.
Yeah.
What's the most important thing they need to know about these civil cases?
You know, the biggest thing is causation.
Causation.
Yeah, it's key.
Okay.
It's not enough to show that an enterprise existed
Okay.
or that they did some shady stuff, right?
Right. Yeah.
You have to the injuries that you suffered.
So you can't just be like, oh, they're shady and I'm being for RCO.
Right, exactly.
There has to be that link
That direct link.
between the racketeering and the harm.
It's got to be the racketeering itself that caused the harm,
Okay.
not just that they were in a position of power in that enterprise.
It's like they say, right, correlation isn't causation.
Exactly.
Just because someone's, involved in some shady business doesn't mean they're automatically on the hook for every bad thing that happens.
Right.
You got to have that direct link.
Yeah, it's got to be that domino effect.
Yeah.
That first domino was the racketeering,
Okay.
and your injuries were the last domino.
Right, with no gaps in between.
No gaps, exactly.
Okay.
So, like you were saying, you invest in a company.
Right.
Turns out they were a front for money laundering.
Yeah.
You'd have to prove that your money disappearing
Yeah.
was because of that illegal activity,
Okay.
not just, bad business.
Not quite as simple as it might seem at first.
No, not at all.
There's a lot of legal strategy that goes into building a right. Yeah, it sounds kind of like a John Grisham novel or something.
A little bit, right.
But it's basically about like weaponizing the legal system, right?
Exactly. Using the courts to go after somebody
Okay.
without a good reason,
Okay.
just being vindictive or something.
So how does that connect to RICO then?
Well, think about it.
Oh.
Exactly.
Okay.
And that can tempt people to use RICO suits to, attack their rivals.
Oh, so you're saying somebody could get hit with a RICO case,
It's possible.
even if they're not really, a racketeer?
Yeah, maybe they're just a business competitor. Or somebody said something the other person didn't like.
Wow, that seems, I don't know.
A little messy.
Yeah, a little messy.
Yeah, are there like safeguards to prevent that? Well, the good news is it's hard to win a malicious prosecution case.
Okay, that's good.
You got to show the person knew their ICO case was bogus from the start
Okay.
and that they did it just to cause trouble.
So the bar is pretty high.
The bar is high for a reason.
That's good. I mean, ICO, it's a powerful tool.
It is.
We don't want people just like using it willy-nilly
Exactly.
for personal vendettas or whatever.
It's not a toy.
Right.
Right, exactly.
And actually, your research turned up cases about this.
Really?
Yeah, lawyers getting sued for malicious prosecution
Wow.
because they brought RICO cases that fell apart in court.
So even the lawyers who are like, handling these cases
Right.
aren't immune.
No one is immune.
Wow, that's pretty intense.
It is a high stakes area of law. High stakes, for sure.
Yeah.
Well, I feel like we really went deep today.
You did a deep dive.
We did a deep dive. Yeah, we went from the mob to mining companies.
From lawsuits to malicious prosecution.
Yeah. What would you say is like the key thing?
The key thing,
For listeners to take away about RICO?
I say it's a powerful law with a fascinating history,
Definitely.
but it's all about the details.
Okay.
Proving that pattern of activity, knowing who's the person versus the enterprise.
Right. Right.
And that whole causation thing in civil cases, that's huge.
Yeah. And let's not forget, you know, the possibility of this malicious prosecution angle.
Absolutely.
The knowledge is power. That's kind of like the whole point of these deep dives.
Love it.
And I think anybody listening today, you've got a good foundation now
They did.
to start understanding RICO,
Sure, yeah.
which is, let's be honest, more than a lot of people can say.
It's a complex law, for sure.
It really is.
Definitely keeps things interesting.
It does.
Always something new to learn.
That's right. And that is all the time we have for today's deep dive.
This is great.
Thank you so much for joining me.
Thanks for having
RICO. RICO. This fucking AI is badass. I'm trying to whip one more up. I might call this a night after that. Open panel if anybody wants to get in. It doesn't look like anybody's here, but we'll just in case. Good old RICO. Gotta watch out for that shit. You get RICO'd up. Old RICO. I fucking love RICO. Fucking love RICO.
Do you have a jurisdictional argument you want to make?
Well, I served notice.
Sir,
on
it's a yes or no. Do you have a jurisdictional argument you'd like to make today?
I have a
Yes
multiple
or
arguments.
no?
Why are you forcing me to say answer?
Because I'm running the courtroom and it's the way I want to do it. Do you have a jurisdictional argument you'd like to make today?
I do, yes.
Then make it. What's your jurisdictional argument?
I'm presenting myself. So I need to know, Article 6 of the Constitution grants me the right to know what jurisdiction is this court operating up under?
State of Michigan.
No, what jurisdiction?
State of Michigan.
Okay, what jurisdiction is the state of
District
Michigan?
courts are legislative courts. That means they're created by statute. The state of Michigan gives me my jurisdiction.
So, okay, is that
I work
criminal
under the authority
or
of the state of Michigan.
What is it? Under what jurisdiction? There's two different jurisdictions under the Constitution. You have admiralty and common law. So I'll need to know.
This is not admiralty.
What is
And
it?
it's not common law.
Which
It's
one?
statutory. You have a jurisdictional argument you want to make?
Well, I served notice.
Sir,
on
it's a yes or no.
G'day folks. I wanted to send a message to people who were protesting, for want of a better term, in Canada, Australia, New Zealand and elsewhere around the world. I've seen a lot of video footage of what they're doing, and I think they are making one very grave potential error, and that is in the nature of the flags they're flying. So everyone has said that these protests need to be peaceful, and all they want to do is speak with the other side. Okay, well if that's the case, you don't want to fly the Canadian maple leaf, you don't want to fly the Australian blue ensign or the red ensign or the Eureka flag, and you don't want to fly the New Zealand national flag. If you're a peaceful protest, and if you want parley, and if you want to put those who are opposing you in a position of committing a war crime, if they should take violent action against you, then there is only one flag to be flying. And that's the white flag. The white flag is the flag of peace, it is the flag of truce, and it is the flag of parley. And to attack someone who's flying, who marches under a white flag is a war crime. So if anyone out there sees this and has the ability to get in touch with people who are organising these protests, what they need to do is tell all those people who are there to get rid of all their national flags, all their alternative flags, and to tie one thing only to the flag poles they're carrying, and that is a white flag if you've got it, but anything white will do. Just fly the white flag. It has the potential to protect you from violence because it creates a legal paradigm for those who would like to perhaps take more violent action against protesters. So if you want a parlay, you need a white flag. If you want to tell the whole world that you're there for peaceful purposes, you need the white flag. This is very important. I can't stress how important this is. And it has the potential to protect you from violence because it will place those who would like to start something violent in a dilemma, in a bind. It is a war crime to attack someone who comes under a white flag. Anyway, hopefully someone out there will see this and pass it on to people who know the people who know the people who know the people who can make an announcement at some of these protests and let the people know.
All right, buckle up everyone, because today's deep dive is a wild ride through the world of the RICO Act. RICO, yeah, I know what you're thinking sounds about as exciting as watching paint dry, right?
Well, I think our listeners might be surprised by what they learned today.
That's what we're here for.
Mm-hmm.
So get ready, because you're about to be that person at parties casually dropping RICO knowledge like it's nothing.
I have a feeling they will be.
So we've got a stack of legal guides and court cases from the past couple of years all about RICO. And believe me, there's some juicy stuff in here.
There certainly is.
Our mission, should we choose to accept it, is to figure out what makes RICO so powerful, how it's used beyond just going after the mob and all the crazy hurdles people face when they end up in a RICO case.
It can be a real legal maze.
Okay, so first things first, we cracked open this 2021 IQ guide, and right off the bat, it throws us a curveball. Turns out, being a RICO person is a lot more complicated than you might think.
It really is.
Like when we say RICO, we picture those old school gangsters in pinstripe suits, right?
Right, but it's not that simple.
Exactly. And this 1991 case, Jun v. Town of Hempstead, really drives that point home. Get this. An unincorporated political association, basically, a group, was considered a RICO person just because it could own property.
That's a perfect illustration of how broadly RICO defines person.
So it's not just about individuals. We're talking about groups, organizations, you name it. If they can own property, boom, they could be considered a RICO person.
Wild, right?
It really shows how RICO can target those complex schemes that involve multiple players, not just one bad apple. Okay, so owning property, even as an organization, could land you in RICO territory. Got it. Now, what about extortion? That's going to be a classic RICO term, right?
It is, though it's actually more common in criminal RICO cases, not so much the civil ones.
Huh. I would have thought it'd be the opposite.
Our 2021 guide actually mentioned it being used in, of all things, abortion cases.
No way, really?
Yeah, some protesters were accused of extortion, the argument being that their actions were meant to scare people and disrupt business.
Wow. Using a RICO in a charge debate like that really makes you think.
Definitely highlights how RICO can end up in situations where free speech and economic harm collide. Talk about legal gray area.
No kidding. All right, let's shift gears to another ICO term that seems straightforward but gets complicated fast. Pattern. Our sources make it clear that proving a pattern under RICO isn't just about showing someone did a couple of bad things.
Nope, 2 strikes are out. Doesn't quite cut it in RICO world. It's about establishing a pattern of racketeering activity, which is way more nuanced than it sounds.
And this Supreme Court case from way back in 1989, HJ Inc. v. Northwestern Bell, really shook things up when it came to figuring out what qualifies as a pattern.
Oh, absolutely. Before that ruling, courts wanted to see evidence of multiple separate schemes, but HJ Inc. changed the game, saying that even a single scheme with a bunch of related activities could be enough.
So it's less about the number of bad actions and more about proving those actions were connected to a bigger, overarching scheme.
Exactly. And that's what makes HJ Inc. so important. It demonstrates how the interpretation of RICO can shift over time, and what constitutes a pattern is still a big debate in legal circles.
Which makes me think that arguing a RICO case from either side must be incredibly difficult.
It's not for the faint of heart, that's for sure. You need a deep understanding of both the specifics of the case and how RICO is being interpreted, which, as we've seen, can be a moving target.
All right, let's shift gears a bit and talk about employers and RICO. You ever heard the phrase respondent superior?
I have. It's Latin, right? Essentially, it means an employer can be held responsible for the bad actions of their employees, even if the employer didn't directly tell them to do it.
Exactly. So when it comes to RICO, does that mean a company could be on the hook for their employees' actions, even if the company didn't directly benefit?
You're exactly right. And the 1987 Petrotech case really cemented that. It was a landmark case that sparked a huge debate about how far corporate responsibility goes under ICAP.
Man, that case must have sent shockwaves through the corporate world. All of a sudden, CEOs are liable for stuff happening under their noses, even if they weren't in on it.
Definitely highlights the importance of things like internal control programs. Companies had to get serious about preventing ICO violations.
Makes sense. Okay, next one is where things get interesting. You remember that huge 1994 case, Central Bank of Denver's Interstate Bank?
How could I forget? Landmark case.
The Supreme Court basically said no aiding and abetting liability in securities law. Everyone was left wondering, what about RICO?
It definitely sent ripples through the legal world.
So aiding and abetting is out for securities cases, but does that logic apply to RICO too?
It's the million-dollar question, and it's one that's still being debated. Central bank created a lot of uncertainty, and no one's quite sure how aiding and abetting fits into the RICO puzzle.
You know, thinking about how complex these RICO cases can get, those class action lawsuits always seem like a recipe for chaos.
Oh, absolutely. Especially when you're talking about proving everyone in the class was affected in the same way by the ICO violation. That's a tough one.
Yeah, and we came across a couple of cases in our research that really illustrate this. One was called Sandwich Chef. What was the story there?
Sandwich Chef involved a group of franchisees who decided to sue the franchisor. They claim the company basically lured them into a bad deal, making all these promises about realized.
So they're saying the whole franchise operation was essentially a scam.
That was their argument. They said the presented potential profits, hid certain fees, basically made it impossible for them to succeed.
So they were alleging a pattern of racketeering, and they wanted class action status to represent all the franchisees who got caught up in this supposed scheme.
Exactly. They claimed they were all harmed in the same way by the franchisor's actions.
But it sounds like the court wasn't entirely convinced.
Nope, not quite. The court refused to certify the class because even if the franchisor was doing something shady, the franchisees couldn't prove that everyone's losses were directly caused by those actions.
Right, because even with a bad franchisor, some people might be able to make it work, while others might fail, even in the best circumstances, right?
That's the point the court made. They said individual business decisions and local market conditions could also be factors in a franchisee's success or failure. They couldn't definitively say that every sandwich shop went under solely because of what the franchisor did or didn't do.
So it's not a slam dunk RICO case just because the franchisor might have been doing something questionable. Each franchisee had to prove that direct link between the franchisor's actions and their own losses, right?
Exactly. And in Sandwich Chef, that link wasn't strong enough for the entire class. And the Lester case we found is interesting too.
Okay, what happened in Lester?
That one involved a classic Ponzi scheme. A group of investors sued a financial services company, claiming they were tricked into investing in a fake real estate venture.
Those Ponzi schemes are like a financial house of cards, just waiting to collapse.
Exactly. And in Leicester, the investors wanted class action status, claiming they were all victims of the same fraudulent scheme.
Seems reasonable. So what was the issue?
The court wanted to take a closer look at each investor's situation before lumping them all together into class action.
But if they were all given the same pitch about this real estate venture, wouldn't their experience be pretty similar?
Not necessarily. The court was really interested in the concept of reliance. Did each investor actually rely on what the company was telling them when they decided to invest?
So it's not enough to prove everyone heard the same sales pitch. The court wants to know if each person actually bought into it and made their decision based on those claims.
Precisely. And that level of individual scrutiny often throws a wrench in class certification for RU cases involving fraud. Courts want to see proof of individual reliance, not just assume everyone was equally fooled.
That's really interesting. So both Sandwich Chef and Lester highlight how proving commonality and causation in these RU class actions can make or break a case.
Absolutely. And these are just two examples of the many complexities that make Argo litigation so challenging and, let's face it, pretty fascinating.
Speaking of challenging, let's get back to the statute of limitations for a bit. We talked about how plaintiffs sometimes try to sidestep those time limits using strategies like fraudulent concealment. Can you break that down for us?
Sure. Essentially, it's a way for a plaintiff to argue that the clock shouldn't start ticking on their Argo claim until they reasonably could have known they were harmed.
So it's like hitting the pause button on the statute of limitations.
Right.
But when could someone actually use that argument?
It comes into play when a defendant tries to hide their wrongdoing. If they actively concealed their racketeering activity, making it impossible for the plaintiff to know they were being harmed within that 4-year window, a court might be willing to give them more time.
So it's not enough for a plaintiff to say, I was clueless about this whole racketeering thing until just now. They have to prove the defendant was actively trying to pull the wool over everyone's eyes, right?
You got it. They need evidence showing the defendant actively hid information, messed with records, or did other shady stuff to keep the plaintiff in the dark.
Can you give us an example of how that might actually play out?
Let's say there's a company that's cooking the books to make their profits look better than they are. And they're really good at it, like next level stuff. We're talking shredding documents, intimidating employees to keep quiet, maybe even bribing auditors.
Sounds like they're going all in on the deception.
Absolutely. Now, imagine an investor buys stock in this company based on those fake financial statements. They have zero reason to suspect anything's wrong because the company's been so good at covering their tracks.
So the investor's totally clueless, and that clock on the statute of limitations is just ticking away.
Exactly. But then let's say a whistleblower comes forward, or maybe a news organization blows the whole thing wide open. Now the investor finally realizes they were a victim of this elaborate scheme.
And they can prove the company intentionally hid the truth. They might still have a RICO claim, even if more than 4 years have passed since they bought the stock.
Exactly. Fraudulent concealment can be a game changer for plaintiffs who are victims of these really well-concealed racketeering schemes.
So it levels the playing field in a way, giving those plaintiffs a fighting chance.
Precisely. It ensures that those engaging in deliberate deception can't just outrun the law forever.
It's incredible how RICO, this law designed to take down the mob, can be used in these complex financial scenarios. It's like a game of chess, with both sides trying to outmaneuver each other.
It really is. And as organized crime continues to evolve, we're only going to see more creative and intricate legal strategies on both sides.
It's kind of mind-blowing when you think about it, RICO, a law meant to dismantle the mob, being used to fight something as complex and ever-changing as cybercrime.
It really speaks to how ahead of the curve the creators of RICO were. They knew organized crime wasn't going to stand still, so they built a framework adaptable enough to handle whatever came next.
So now we've got this law from the 1970s that could be a major player in taking down digital age crime. Talk about a blast from the past.
It is a bit of a paradox, but when you break it down, cybercrime often has the same DNA as traditional racketeering, organized groups, patterns of illegal activity. It's all about the money.
Right. This isn't some lone wolf hacker in a basement anymore. We're talking massive international operations, ransomware, data breaches, the works.
Exactly. And those operations often leave a trail of digital breadcrumbs. And that's where RICO's flexibility really shines.
Because even in the digital world, investigators can follow the money.
Exactly. Law enforcement is getting really good at tracing those cryptocurrency transactions, uncovering those hidden online connections, and pinpointing the key players behind these schemes. It's like piecing together a digital puzzle, building a RICO case one click at a time.
So even if these cyber criminals are hiding behind fake identities and operating across borders, RICO could still be the tool to bring them down.
It absolutely could. But it takes a deep understanding not just of the law, but of the constantly evolving tactics these cyber criminals are using.
It's a game of cat and mouse. As technology changes, the law has to keep up.
That's the thing about RICO, it can adapt. And it's not just about going after the hackers themselves. RICO could target anyone who knowingly participates in or profits from these schemes. The people providing the infrastructure for the attack, laundering the money, even helping to cover it up, they're all potential targets.
So RICO casts a wide net, taking down the whole criminal enterprise, not just the most visible players.
Precisely. And that's what makes it such a potent weapon against organized crime, both on the streets and online.
Hearing you lay it all out like that, it almost feels like the people who wrote RICO could see the future of crime, like they knew this digital world was coming.
It really speaks to their foresight. But as with any powerful tool, there's always the potential for misuse.
Because RICO's flexibility, while a strength, could also be its weakness. It could be applied too broadly, catching people or businesses who are completely unaware of or had nothing to do with any criminal activity.
That's the danger, the fine line. As we explore how
Well, that's all, folks.